People are often aware that a revocable living trust can be an excellent option for the 4 Ds: death, divorce, dementia, and debt. But there's one huge mistake that most people make when they create a revocable living trust that cancels out the entire thing and causes you and your family probate, attorney's fees, conflict, all of the things you are trying to avoid. Stick with me to find out what that one major mistake is and how to avoid it. I'm Anna Burr with Burr Law. And if you have a revocable living trust or you're thinking about getting one, this video might be the most important estate planning video you'll ever watch, because today we're talking about funding your trust. Here's the truth that surprises a lot of people. A trust that isn't funded often does not avoid probate. I see this all the time. Families come in believing everything is set up perfectly, and then we discover that the trust was never properly funded. So today I'm going to walk you through what funding a trust actually means, why it matters so much in Aurora, what assets should go into your trust, common mistakes I see, and how to make sure your trust actually does what you created it to do. This is educational only, not legal advice, but by the end you'll know exactly what questions to ask your attorney and what steps to take to make sure your trust works the way you intended it. Let's start with the basics. What does funding a trust mean? When people hear funding a trust, often they have no idea what we're talking about, but they might have an idea that it means putting money into a bank account. But funding a revocable living trust really means something else. It means changing ownership of your assets so the trust, not you as an individual, owns them. If your trust doesn't own your assets, then legally, your trust has nothing to control when you pass away. I often describe a trust as a legal box, and the trust can only control the things that have been put inside that box. Creating the trust itself is building the box. The trust is empty when it's first signed. Funding the trust is putting the things inside it. An empty box doesn't do much. In Colorado, probate is often described as simpler than in some states, but simpler does not mean easy, and it does not mean free. Probate still involves court filings, delays, public records, attorney's fees, personal representative responsibilities. If an asset is not properly funded into your trust or otherwise structured to avoid probate, then it may still have to go through probate court in Colorado. That means your family may face delays, your privacy may be lost, and your carefully drafted trust plan may not fully work. Your trust only controls what it owns. So what assets should be funded into a trust? Let's talk about the most important asset types and how they're handled. First, real estate. In Colorado, real estate is one of the biggest probate triggers, and for a lot of people, it's their largest asset. If you own a primary residence, a rental property, a vacation home, and it's titled in your individual name, that property may require probate when you die. Funding real estate into a trust usually means recording a new deed and transferring ownership from you individually to your trust. This is one of the most critical and most commonly missed steps. Asset number 2, non-retirement bank accounts. Checking and savings accounts can often be retitled into the name of your trust. As an alternative, the trust could be added as a joint owner of the bank account. Now, changing the name of the trust involves working with the bank, updating the account ownership, providing a trust certification, and sometimes banks push back. Sometimes they don't explain it very well. Sometimes the person you've gone in to see doesn't understand it very well themselves. This is where guidance matters, and this is where we can help you to make sure that your trust is funded so that the time and money and energy that you've spent putting this together will actually result in what you want in the end. Third, investment accounts or brokerage accounts. Taxable brokerage accounts are often excellent candidates for trust ownership. Those accounts can usually be retitled to the trust without much difficulty. You'll continue to use your Social Security number during your lifetime, and the asset will pass seamlessly to your successor trustee at death. For retirement accounts, special rules sometimes apply. This is where people often get confused. Most retirement accounts, like IRAs or 401ks, are not retitled into the trust during your lifetime. This is for tax purposes. Estate planning is a careful balance of estate taxes, personal taxes, death taxes, and income taxes. So instead, we generally have these passed by beneficiary designation. Sometimes the trust is the beneficiary. Sometimes a spouse is. Sometimes it's a different family member or somebody else entirely. It all depends on tax planning, ages, and goals. This is an area where a one-size-fits-all advice can cause problems. Your specific needs require careful consideration and strategy for how to approach and handle these taxable assets. Fifth, life insurance. Life insurance also passes by beneficiary designation. Again, a trust might be the named beneficiary in certain situations, such as for minor children, for special needs planning, for asset protection concerns. But again, this must be done intentionally and after a conversation with your attorney and a full understanding of the goals and the implications of the activity. Sixth, personal property. This is all your stuff. If you took your house and pulled the roof off and flipped it over and shook it upside down, what would fall out? Your clothing, your furniture, family heirlooms, jewelry. This is all of your personal property. Stuff that doesn't necessarily have a title or a deed, but still needs somewhere to go. Most trusts include a general assignment of personal property, which covers all of these things: furniture, jewelry, art, household items. But high-value items may need special attention. What are some common mistakes we see in Colorado estate plans? Let's talk about those mistakes, because avoiding these can save your family a lot of stress and money. Mistake number 1, well, my attorney didn't tell me this. Funding is often treated as an afterthought. Clients think, well, I signed the document, so I'm done. But in reality, signing is only half the process. Signing is only creating the box. You still have to do the second part of moving the assets into the box. Mistake number 2, the deeds were never recorded. I regularly see trusts where the deeds were prepared but never recorded with the county. Legally, that means the trust might not own the property. Depending on how it's been set up, that recording is critical, and that's something that we always make sure to handle for our clients in estate plans. Mistake number 3, new assets don't get added. All right, so here's the situation. You created a trust. It was funded. Everything looked great. And then years later, you buy a new house. You change banks. You move to a new investment broker. If nobody updates the trust funding, those assets may still go through probate. The good news is that if you've created a trust, putting your new home into that trust is fairly simple as long as you inform your realtor and your title company ahead of time. Your attorney can help you with this. Mistake number 4, beneficiary designations conflict with the trust. Outdated beneficiary forms can override your trust. They can cause uneven distributions. They can create family conflict. Everything in your estate plan needs to work together as a system. This is why careful thought and strategy is so important in estate planning. Your attorney will see things through, evaluate different scenarios, determine what the best course of action is for all of these moving parts to make sure that they're all headed towards the same goal, which is the one that you created. So, how do you know if your trust is properly funded? Well, here are some practical steps that you can take. First, review ownership. Ask, who owns my real estate? Check county records. Check with your attorney. Who owns your bank and investment accounts? Check with a financial advisor or look at the statements that come to you monthly from the bank. If it's you as an individual, ask why that is. Again, sometimes that's an intentional decision, and sometimes it's an oversight. If you're not sure, it's important to check with an attorney and make sure that everything is lined up properly. Step 2, review your beneficiary designations. Make sure they're up to date, that they align with your trust plan, that they still make sense for your family today. What happens often with beneficiary designations is they're signed at the beginning of opening the account or creating the policy, and then they're never revisited. It's very important to take a look at these and make sure that they are still in alignment and still on file with the financial institution. Step 3, get a funding review. A good estate plan includes a funding checklist, ongoing guidance, periodic reviews, and especially after major life changes like marriage or divorce, new children or grandchildren, buying or selling property. It's a good idea to review your trust every 3 to 5 years at minimum, or more frequently if one of these major events has happened. So, what happens if a trust isn't funded? Well, when a trust isn't funded, families are often shocked and disappointed to learn that probate is still required. This is extra legal work that's needed. The process becomes more complicated and emotional on top of an already emotional time. The trust often is not what failed. It's the funding that failed. So if you're in Colorado and you already have a trust and you aren't sure it's funded, or if you're considering a trust and you want to make sure it's done right, I encourage you to schedule an estate design meeting with us. We are qualified estate planning attorneys here in Colorado, in Aurora specifically, and we would be glad to help you. Your trust should do exactly what you created it to do, which is protect your family, avoid probate, and give you peace of mind. I hope you found this video helpful. If so, please like, subscribe, and share it with someone who has a trust sitting on a shelf and hasn't looked at it in the last 15 years. Thank you for joining me today, and I'll see you in the next video.